I didn't mind that.
You probably were not.
On schedule and
One second. Okay, go ahead.
all right, we would like to go ahead and call to order the Pleasant View Planning Commission meeting for March 7th, 2024. It is now 6:03, and we'll go ahead and start the evening. I'd like to make notice that Commissioner Farr is joining us electronically tonight. We appreciate her joining us for this meeting. We'd like to go ahead and call to order and ask Commissioner Gosner to start us out with pledge of allegiance and opening prayer, reading or expression of thought at this time. I pledge allegiance to the flag of the United
States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our dear Heavenly Father, we're indeed grateful for the opportunity to gather tonight as citizens and friends in the small and great community of Pleasant View, Utah. Thankful for the beautiful evening we're having, for the return of sunlight, and all the wonderful things that take place here in our town. Thankful for the opportunity to consider any changes or opportunities that might come to Pleasant View. Thankful for the training we're about to receive tonight as well. And thank you for all of our city administrators and all of the hours that they put into making our city function. And this is our prayer in the name of our Savior Jesus Christ. Amen.
Thank you. We do have a declaration of conflicts of interest, but I don't see anything on the agenda for this evening that would require us to declare anything unless, really some problem with the training that will take place tonight. We do have our meeting minutes approval, consideration for approval of meeting minutes for the December 7th, 23, January 4th, 24, and February 1st, 24 meetings. I noticed on there that she had highlighted, usually in yellow, and she highlights, that was mostly for the attendance. I don't know whether the email back, but I was in attendance probably was, I don't know if we just need to have a roll call for who's in attendance, or what's the best way that you would like to address that?
Just if anyone knew if the list was inaccurate, there's one correction on the December meeting that I mentioned to her that Commissioner Cotter was not in attendance, and so he'll be removed if he was on that. But if you're aware of someone who was listed that wasn't there, or who was there and wasn't listed, if you let us know. We can just, if you want to authorize to make an adjustment for attendance, that would probably work. So
And having read it, I thought it looked, for the most part, about complete, other than the attendance just be out there.
I know I was absent for January 4th.
okay, that's helpful.
As much as I would have liked to have been here, Thailand was more in there.
That's right.
So if you want to make a recommendation with adjustments for attendance.
So does someone like to make a motion and possibly make that recommendation allowing staff on the attendance as needed?
I could make that motion, I suppose. I'd like to make a motion that we accept the minutes as drafted, with the exception of some alterations for attendance.
We have a motion on the table. We have a second.
Second.
We have a second. So first by David, second by Ryan. All in favor, say aye.
Aye.
Opposed? Okay, we'll move from our meeting minutes to our administrative items.
Chair, real quick, if I could just make a technical note. that with the minutes, the person that's been working on them, first of all, this should catch us up to all past meetings have been.
Oh,
So that's a good feeling. It's been a big project. The person doing the minutes has stated that there's been some difficulty hearing planning commissioners. It's something with the sound system. I don't know if it's been resolved or not. So if you could just make an effort to speak into the mics. So anyway,
it's usually when Sarah's back there, yelling in there, you don't pick that up. So
Right,
I'm trying. Okay,
I just hear your mind, but not so much Brandon's. I don't know.
oh, okay.
we need to move one over closer for him. We'll go ahead and move to administrative item. We have 3A, the election commission of leadership for 2024 calendar year, commission chair and vice chair. We've gone ahead and we've already set our calendar for the year, and now if we decide for discussion is how we want to move forward for this year. I'm open, I think the first thing we want to do is have a discussion on how we're going to move forward. Thoughts on how we can do it. We can either do a closed ballot or just an open ballot. We can move forward at that time. So I'll open it to the table for discussion. And Julie, wave your hands and tell us anything that we'll watch for you to chime in whenever you're ready.
Can you hear me?
Yes.
Okay.
Does that mean you want to talk right now or are you waiting?
No, I was just waiting. I'm fine with making a motion that we nominate Andy Neff as our chairman for next year, if he's willing to accept.
I'm open to finishing out here since we've started, but I'm open, if it's okay at this time, Julie, before we act on your motion, that we have discussion
Okay.
around the table. Others have discussion, thoughts, or concerns. John's ready to grab his mic. You ready to talk?
I think an open process is just fine, and I'm ready to second her.
And can I ask before we go see, did we decide pretty much on the first Thursday of each month for the meetings?
Yes.
With one or two exceptions.
Two exceptions. So you want to have a calendar review because of the holidays or spring break. I think there was a couple of exceptions.
So April's will be on the 18th instead of in the third. So that's the third Thursday instead of third or second Thursday instead of the first. And then I think the July or August got moved as well.
You know, one of those July, because of the holidays.
So which one will be the date in July?
I don't. Oh, sorry. Go ahead.
No.
Okay, back to our topic. Topic at hand, questions, thoughts, other nominations. I second. I will be happy to continue this year since we're already in March, which I can't believe the calendar year is already flying. So if no one else is making a motion at that time, we have a motion by Julie to nominate Commissioner Neff to continue as chairman. We had a second by Sean. Any discussion on the third? Any discussion on that? All in favor, say aye.
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 Opposed? Okay, it is unanimous. Okay, now vote for a vice chair. I think we definitely need to do this as a stepping ground. So Julie's been amazing. She would be happy to step in again, so we can help her. And she's been great to step in. And she'll be ready to step in next December to replace me. So, well, we're partly through the year. I'm hoping for Julie or if anyone else has the desire to want to step in the role.
Chairman Neff, I was going to say it's a wonderful opportunity being vice chair to learn things and to grow. If somebody else would really like to do this position, I would like to support them in that. There are some things we've been involved in that I wouldn't mind finishing up, but I am more than happy because at this point in time, I can't commit to next year of how involved I can be after the next year or two. So I'm just throwing that out there.
I'll make a motion, that we appoint Julie Barr as the vice chair of the planning commission for the 2024 calendar.
We have a motion to nominate Commissioner Parr to vice chair. Do we have a second?
I'll second the motion to have Julie step into that role.
We have a second by Dean. All in favor, say aye. Aye. Julie, you're stuck with this again for the rest of this year. Sean was quick to make a nomination, so we didn't have to hurry enough. So I learned that one back. That's what you're supposed to do. Thank you, everybody. And I do appreciate the support from the team here. I've learned a lot and continue to try to learn and helping not be so tongue-tied. So I appreciate you guys giving me the opportunity. In light of trying to keep ourselves on time schedule and keep ourselves moving, we would like to go ahead and move to item 3B on our administrative, which is our land use training. We're required by the state to have X amount of training and hours per year. And so this will help us meet one of those requirements for this year. We have with us, I'm actually going to let Brandon, you know, I'm going to let you introduce him for us this evening and we can get started on the training.
Yeah, sure. So we have with us tonight Jordan Colomar. He's the lead attorney for the office of the state office of the property rights ombudsman. The role that they fill in our state is it's a relatively unique system. It's wonderful in helping avoid litigation on a number of levels. When cities or property owners in the state have concerns with either an action that a city's taking, or maybe a city has a concern about whether they, you know, whether some requirements are legal or something like that, they can call the property rights ombudsman and get, you know, an opinion and some perspective. And then they also operate in mediating disputes when they, you know, can't reach a resolution. Then they, you know, they can go to the two parties can go to the ombudsman's office and see if they can have them mediate a resolution, and they'll give their ruling. And it ends up, you know, Jordan can speak in more detail regarding the facts, but it helps avoid a lot of litigation in the state and keep the tension down in those negotiations. So Jordan heads up the office. He also presents pretty regularly at like APA conferences and other forums to provide information and raise the education level on land use law and principles in the state. And they have a team of attorneys that you can contact, and he's the lead one. And so we're very pleased to have Jordan here tonight. So sure, if that works best for you.
Yes, yes. We're open. We're in training session mode
Oh, no, just.
until he tells me that's not what I'm supposed to allow you to
No,
do.
seriously, the state ombudsman's office is fabulous, but I can't tell you how many times I contacted Jordan and also another attorney / planning. Jordan's background, and I'm sure he can tell you, is planning, but then he became an attorney. And Marcy Jones down there as well, and he knows his stuff. He's fabulous. Then you guys should be calling him all the time. There you go.
I'm just realizing back of my head is bald, guys.
Welcome. We appreciate you coming.
Thank you. Glad to be here. Should we jump in? Ready to go?
Don't be informal if you don't mind.
Brandon, I forgot to ask you, did you get the slides that I sent you?
I did get them. I need to transfer them from one computer to another really quick.
No
So
worries. While you do that, and Brandon actually gave a pretty good kind of primer on what our office does, but that's one of the things I like to talk about to start is what our office is, who we are, what we do, just so you know those things, because frankly, we are a resource. I do want to let you know, you said that this is state required training. I was not the one that required it. The requirement doesn't come from our office, okay? But I think it is good that people get the training and you know, what we always say is good decisions are decisions that comply with the law, right? That's a lot of what we do in the Property Rights Ombudsman's Office. We are a neutral, independent state agency. We've been around since the 90s. There are 3 attorneys in the office, and just last year, they added to our office, the legislature did, a training director, kind of in line with the need for training throughout the state. So Rob Terry is our training director. He has a planning background. He's a great resource as well. And then there's the 3 attorneys, me, Marcy Jones, and Rick Glenn. And there's, kind of going along with what Brandon said, there's 3 primary things we do. We spend a lot of time training. So we try to be very accessible. When Brandon gets the slides, he'll put up my email address and our phone number. When you call in, we try to get you in touch with an attorney when you call in. And if not, then within 24 hours, we try to get someone to get back with you. Since we're a neutral agency, fortunately, we've developed a reputation of being neutral. So it isn't common that in the same day, we'll get a call from a property owner or a developer. And then in the afternoon, we'll get a call from someone in the city, a planning commissioner, a city council member, staff member about the same issue. We keep confidence where confidence is needed to be kept. We also try to, encourage communication where communication wants to happen. But when we get calls, we answer questions, we provide context and insight, and then we go around the state from community to community and provide these kinds of trainings. We recognize that planning is largely a local concern. You guys are dealing with things that are different than what my community where I live in Riverton is dealing with. And we deal with things different than what people in Springdale do, right? So that's why we go around and provide these trainings, just so we can hopefully address topics that are interesting and relevant to you. The next thing we do is dispute resolution, mediation, and provide advisory opinions. So like Brendan said, if there was a dispute over a land use application and someone wanted an independent analysis of what a court might say to provide that acts as a dispute resolution tool, you can come to our office and say, hey, Ombudsman's office, give us a legal analysis. We've done approaching 300 advisory opinions in the history of the office. They're all on our website. So you can go there and kind of see what we've said in the past about different topics and items. And then mediation, we primarily do mediations on the eminent domain side. So we do everything related to land use and eminent domain. When the government needs private property for public use, like a road or a water tower or whatever, right? Then the government, we act as a neutral third party to help mediate those disputes. And we also mediate land use disputes as well sometimes. So that's kind of the 3 areas that we primarily work in. And yeah, like Sarah said, give us a call anytime. Send us an email, give us a call if we can be helpful with anything. So as far as what we do and those types of things, any questions? Okay, so are we ready to jump into the fun part? Yes. Hopefully, right? Okay, so yeah, and there's my information. And yeah, Brandon, you're welcome to distribute these slides.
Okay.
To the commissioners.
We got it, so we take them.
Okay, so yeah, so if you want to go to the next one. Honestly, this is the slide that we spend the most time on, and I don't have any intention of getting to the other slides if you don't want to, frankly. My goal is for this to be a conversation, talk about issues that you guys find interesting, useful, that you want to understand. These are some common issues. We call this our Jeopardy board, common legal issues in land use. These are general categories, and if there's a category you want to talk about that isn't up there, that's on the table as well. But this is just kind of to get things started, to get the juices flowing. You see something on there you want to talk about, let's talk about it. Brandon and I had a really good conversation before earlier this week. He kind of presented some topics that would be useful to bring up and discuss. Inevitably, we want to talk about legislative and administrative decision making. That always comes up, and it's really, in a lot of ways, kind of the basic foundation of making good land use decisions, is understanding that decision. Another one that we want to definitely hit on, exactions. So that's actually the #1 topic. that we receive advisory opinion requests on is, is the city imposing a lawful exaction? They're requiring me to build this road, they're requiring me to put in this, well, put in this water line, or some public facility. Is it lawful there for them to do so? Are they requiring too much? So we're going to talk about that one. Where do you guys want to start? And I'm happy to, again, it's a conversation, so anyone in the room, if you have a question or a comment, please chime in. If there's no burning questions, then we can jump, I can do an overview of legislative and administrative decision making,
Let's start there.
and then that kind of provides a springboard sometimes. Brandon, if you want to go down one slide. So this is, this kind of presents a broad overview of the difference between legislative versus administrative decision making. So going back to civics class, legislative decisions are decisions that make the law, right? That's where we're setting policy. We're saying, okay, this is what, in the land use context, this is we're talking about the general plan. We're talking about your zone map and your zoning ordinance. These are the rules that are going to govern our relationships and the decisions that we make, right? When you make legislative decisions, there's that the idea of separation of powers, right? The courts typically defer to your legislative body in deciding what the law should be that governs, right? There's also the state legislature, and Sarah and I just had the conversation that they step in more and more every year, right? To kind of tell you what the rules are and what the guidelines are. But by and large, the local government, through their legislative body, has the ability to say, okay, these are the kinds of zones that we want to have in our community. This is where we want residential to be. This is where we want commercial to be. These are the rules that we want to apply to those uses and those types of things. You enact all of that through your ordinances, okay? And as far as whether or not a decision in the legislative context is legal, you see down there at the end that we talk about the legal standard of review. So if the decision is consistent with applicable law, so it's consistent with state law and federal law, if there is anything applicable, and if it's otherwise reasonably debatable that the decision that's being made is in the public interest, then, the legislative decision is going to stand. So if you say, hey, we're going to put in place an R110 zone in this area of town, as long as that is reasonably debatable to be in the public interest, and there isn't a rule at the state level or the federal level that says it's illegal, the court is going to say, yep, that's legal, that's good. You guys made the right decision, okay? Once you have all those rules in place, and then someone brings in an application to actually develop their land or use their land in some way, now we're talking about subdivisions, we're talking about conditional use permits, site plans, building permits, variances. That's kind of its own animal. We can talk about that if you want. But these administrative applications where they bring them in and say, hey, this is how I want to use my land under the rules that are in place, things tighten up a little bit now, right? And you don't have the ability to say, do we want this here or not? Because that's what you ask at the legislative stage. Once someone brings in an application, they've paid their fee, they've given you all the documents, you need to start reviewing things, they've got a vested right. Then at that point, the legal standards of review is, it has to comply. You're basically just reviewing your ordinances to make sure that everything complies. And then where there is some sort of a fact that needs to be determined or settled upon, or there is some sort of discretion given in your ordinance to apply something in some way, then you have to provide evidence, substantial evidence, we call it, right? Some good evidence, something that's factual, relevant, and not just an opinion, right, to support a decision. And so that's kind of the broad distinction. You as planning commissioners, right, you act in both roles sometimes, and it's important to recognize which hat you have on and when you have it on. Because one of your roles is to be an advisory body to the Sarah and the city councils. Yep, you guys make recommendations every time an ordinance is proposed or is going to be passed, or the general plan. First, it has to come to you guys. You have to have a public hearing. Thank you for doing that part, right? And then you have to receive public input. And then you have to provide a recommendation to the city council on legislative decisions. in those cases, it's really important that you gather all the information you think is relevant and interesting and useful, that you hear all the opinions that are out there, that you have an open and public process, right? And that you provide a recommendation that you think is gonna be best for the community, right? And it's gonna strike the right balance. There's always, we talk about, there's two things that are always kind of a little bit in tension. Hopefully they align most of the time. Sometimes they don't, and that's the public interest and private property rights, okay? It's wonderful when they line up, but when they don't, it's your job to figure out what the proper balance is, right? As far as how your ordinances look. So striking that balance can be difficult.
It's
Please,
okay, if everybody just jump in and ask.
yes,
questions.
I hope so.
Maybe that'll lead us a little bit, because I think sometimes this body, for a few years, with two different people, that kind of wanders a little bit.
Yeah.
And I think sometimes it gets a little muddy between the legislative and the administrative. Because we're making a recommendation to possibly change the ordinance, and we're listening to the public, which the public would like this, but then we need the rights for the citizens.
Yeah.
But once someone comes in with that application, this group is kind of locked to what's on the books, is that right? I mean,
Absolutely right, yep.
but I think sometimes our hearts get into it because like, I may not want to vote for that, or everybody that lives around me may not want to vote for what's on the books.
Yeah.
Or, hey, well, these other cities allow this and this, but that's not what's on our books, right? So I think sometimes it's separating when and how much interpretation we're allowed to without getting ourselves in trouble. I guess that's where sometimes we all get a little bit muddy, because I think we want to do this, but it's not necessarily what's allowed. I guess that's what we call your office, right?
Yeah, and I mean, you're right? Everyone's human, emotion gets into it. It's really important that you try to, even on your agenda, try to separate the items, right? Hey, these are, and maybe you do this already, I don't know, but
He does a good job.
yeah, you have legislative items, and that's when you put on that legislative hat, that policymaker hat, right? And you can talk about, do we want this in our community? What do we want things to look like, But you're absolutely right. Once you get over into administrative decisions, now, public input becomes what we refer to, what the courts have referred to as public clamor. Right? It's not, people, when they're sharing their opinions about whether or not you should approve this subdivision that complies with all the ordinances. Well, we don't want that subdivision over there. You can't listen to that anymore, right? This conditional use permit that complies with all of the standards and the ordinances, it complies with all the specific requirements. There are conditions that we can impose to mitigate all the reasonably anticipated detrimental effects that we've identified, right? They're entitled to approval. You can't ask, well, yeah, we actually don't want that dog kennel over there. Well, the ordinance says dog kennels are allowed over there, right? Now, for future applications, you can go back to the drawing board, right? You can say, you know what? We shouldn't have allowed that dog kennel there. You can go back and you can have a public hearing. You can look at taking it out of that zone if you think it would be in the public interest to do so, right? But as far as that application is before you at that time, like you said, it's an administrative decision. You're just looking to making sure it complies with the rules. And if it does, then at that point, the property rights take precedence, right? And they're entitled to approval of that application.
And can I ask the question?
Yes.
So, Jordan, if somebody comes in and there's specific conditions within the ordinance that says setback has to be 15 feet or whatever else, and the applicant says, well, that won't work for me at this spot. Can't you allow a variance or something to allow 18 feet or 10 feet? But if it's specific to actual feet or whatever else the ordinance says, that's not.
Right, yes, so the rules.
You can't change it just because it won't work for that applicant.
Right, that's called tyranny.
Pretty much.
So the rule of law, right? That means that the ordinances go both directions, right? So while the property owner is entitled to have their application approved according to the ordinances in place, they're also required to comply with those ordinances. And it's the same for you guys, right? You're required to follow the ordinances, all the mandatory provisions of the ordinance, okay? And you don't have discretion where there isn't any. Now, I have seen provisions that say, you know, the setback is 15 feet, but if you make such and such findings, or if there's a hard, you know, you can build
But
flexibility.
that has to be written in the ordinance.
Correct. So you can build flexibility into your ordinance, but it has to be written in there. And you have to follow the procedure that's outlined in the ordinance to make that decision, right? You can't just look at a scenario and say, you know what, I don't think this is what we intended, or I'm not so sure, right? You can't do that. You
Or
have
that's really
to,
stupid because nobody else does that.
right.
Okay.
Can I add a couple caveats?
Okay, please, we're just gonna leave this open discussion.
Yeah.
So question, I'm trying to-
No, you go ahead, go ahead.
so if the ordinance is ambiguous,
Uh-huh.
how is it interpreted in favor of the jurisdiction or in favor of what?
I love you.
Because I think that's where we get in trouble. Not in trouble, but that.
Ambiguity, if we're not specific in the
Like you may have
ordinance,
some
we're not-
experience with this one so far.
We never.
Other
ambiguity.
entities.
Never do that.
Sorry.
It's a great question.
This is for the benefit of our commission, Sean, so.
It's a great question, and there are some areas, as I understand it, of the law. Okay, so ambiguity, let's talk about that, right? Ambiguity, the way I define it, the way I think about it is whenever you can look at an ordinance and you can read it in a way that two reasonable people read it and draw different conclusions, you have an ambiguity, right? There are areas of the law, different areas of the law interpret that differently. In land use, and when we're talking about property rights, the court is very clear to say that because your ordinances restrict the free use of property, that's the baseline rule, is that people can use property the way they want to as long as it doesn't cause a nuisance or hurt anyone else, right? But because that's the baseline rule, they've also said, okay, land use regulations, because we need ordered communities, will allow local governments to put in place land use regulations to govern the use of land. But if a land use regulation is ambiguous, if it's vague, if it can be interpreted more than one way, then you always interpret to favor the property owner's desired use. So tie goes to the property. Historically, long before I've ever been around, right? You would have communities, and it still happens today, that would say, well, let's make that just really broad, let's make it kind of vague, so when the application comes in, we can interpret it the way we want to. You are going to get burned if that goes to court, right? And it's just not a good decision, right? So, and the legislature, they hear stories, okay? And they step in sometimes, and these are the scenarios where the legislature hears stories and starts to whittle away local control. It's when they hear local governments kind of being cavalier with how they're applying their ordinance. So the best practice is to make your ordinances very specific and to say what you want them to say. Because if they don't say what you want them to say and someone comes in and asks to do something and you can read it in a way that allows them to do that, they get to do it.
So if you have a certain thing that, like, if you have a driveway, parkway, whatever, you better define what it is.
Right. Yep. Yeah, be specific where you can be specific. That's always going to be in your favor. So,
Can I add one
yes, please.
caveat, and you can comment on it if you want? So on the legislative or the standard of review for administrative decisions, I believe there's an additional portion to the phrase substantial evidence on the record is, I think, a few more words that are part of the standard. And, you know, essentially what's defensible is only what ends up on paper or in a record somehow, generally. So what's helpful is when you make motions and you make a decision that you state your reason for the decision. It could be as general as, I make a motion that we approve this because it complies with the ordinances, in the applicable zone for the property. If it's probably more important that you make that statement if you're denying or tabling an application, because that's where there's more legal risk, generally speaking. And so if you're going to deny an application, then you want to be able to state on the record potentially what your reasoning for doing so. It should tie back to some substantial evidence that's been presented in the hearing, either in a staff report, or there are times when the public if there's a professional from the public that they present something that's substantive based on a report that's been performed or something by a private party, that can be considered substantial evidence on the record as well. So do you have, you tell me if I'm missing anything or?
No, very well said. That's a great comment. And you're absolutely right. And there was a recent, I guess it's not so recent anymore, probably about 6 or 7 years ago, the Utah Supreme Court very explicitly stated that, hey, yeah, your evidence, the substantial evidence that you provide to support a decision has to be on the record. Okay, and like Brandon said, your record, it can be your staff report, it can be things you say that then are distilled into your minutes. But you definitely, anytime you make a decision that is going to be supported by evidence, that needs evidence to support it, you want to make sure that that is, like Brandon said, stated, it's in the record, and that it's somewhere that someone can look to and find independent, right? Know what you used and how you made your decision. Go ahead, Nancy.
Sorry, I just had one more. When staff is making a recommendation to the planning commission, that should be also considered heavily because they've done the research, they've looked at the ordinance, they're making a recommendation to them of either non-approval or with conditions based on the research they've done with the ordinances.
Yeah, and that actually brings up an interesting point. That's something I always like to ask and talk about. So the individual who, or the body, the entity who makes a legislative decision, we refer to them as the legislative body. The decision maker for administrative decisions, we refer to as a land use authority. And that can be one person, it can be a body, it can be a hearing officer. Does the city council act as a land use authority?
We are the land use authority in almost everything except for minor subdivisions and conditional use.
Okay,
And the new subdivision rules of the state.
Well, which deal with minor subdivisions and conditional use.
since I am the independent guy in the room and I make everyone
Yes.
mad,
Yeah.
that is not the best practice. I will just say that, right? And-
What,
and-
to have the city
have-
council as the land use.
To have the city council as a land use authority.
Why?
Because you're too good at making legislative decisions. You're too good at listening to public input, right? People expect you to, right? So people are gonna come to hearings and they're gonna say the city council can fix our problems. The city council can make this right, okay? The land use authority, that's not their job. The land use authority is a technical review, right? They're looking at it and just saying, hey, does it comply? Now, it happens,
No, it's
right?
true.
And there are entities everywhere. You're not the only ones that do it, right? I'm not throwing anyone under the bus. But if you talk to kind of like the industry best practice gurus, they'll say, hey, make most of your land use applications staff approved, right? If it's a very technical inquiry and all you're doing is going through and making building permits is the perfect example. Do you guys still hear building permits?
No, city of the city.
Your staff is building those building permits, because all they're doing, right, is they're going through, it's technical stuff. They're making sure that it meets the height requirements, that the foundation looks good, and that everything is proposed according to the ordinances, right? That's staff, okay, and then if everything looks good, they approve it, right? For conditional use permits, site plans, subdivisions, things like that. You know, the city council can appoint Brandon as the land use authority, frankly, right? And then it never comes across your table or there, right?
Better give Brandon some staff. That's what it is.
Absolutely right.
Yeah, some more stuff.
But yeah, your, as far as your administrative decisions are concerned, you want that to be as administrative looking, as technical as possible, right? And sometimes the planning commission is appointed as the land use authority and it never goes to the city council, right? But you can also just say, hey, we have a staff member that's designated to do that work. The other thing to keep in mind as well with administrative decisions, the land use authority does not have to have a hearing, a public hearing. Okay, so the public has no entitlement to speak to a land use application, to an administrative decision.
Because it's already been done when the ordinance was created.
Right, yep, the public they get involved when you're making policy, and that's the legislative side of
Yeah,
things, right?
really, they're just checking it out to make sure that we can't change anything in that way.
So can I add a couple things?
You bet.
I'll just make a brief comment and then Commissioner Farr has stated that she has a question as well. She should be able to speak, but so this is a silly metaphor, but this is what I use in my brain.
Yeah.
Is if you think about Monopoly or another board game, like sometimes when you read the rules to a game, I don't know how you are, but in our family, we've found a number of times where the rules aren't clear or something. You should decide to clarify the rules before you start playing the game. Once you start playing the game, you can't change the rules middle of the game, right? So once someone puts their, their figure on the board in Monopoly or whatever, you started the game and the rules should be set. And if you think about that figure as an application that's coming, is complete and they paid their fees, then the rules are set. And then if you don't get what you want out of that application, but you have to approve it, then that's an opportunity to think, okay, well, we need to go change the rules for future applications. So the next game we play, we'll clarify these rules before, someone comes in. So I like simple things. So that's how I think about it.
No, the way you're explaining it makes perfect sense.
Super. So Julie had a question?
Yeah, Julie, can you, are you able to, oh, go ahead.
Mr. Collmore, I would like to ask you a little bit about the.
My dad's Mr. Cooper, you can call me Jordan.
Let the record reflect.
Okay, Jordan, I would like to ask a question about the general plan. If somebody comes in, my understanding is that when we are making administrative decisions, we are really following the general plan because those decisions have already been made. They're legislative decisions. And unless you're changing the general plan, aren't we just following through with that? Can you just address the how, when, why that you would change the general plan?
Yes, that's a great question. And so your general plan, when you pass your general plan, that's a legislative decision, right? But the general plan itself becomes an advisory document, kind of a visioning document. So it's even further removed. The way I think about it is you have your general plan and it's kind of overarching everything and it's kind of setting the goals and pointing the city in a general direction about where they want to go, right? And then your local ordinances are what implement that vision through rules that you're going to apply to applications. And then the application, right, when someone brings in an application, you're looking to the rules that are in place in your ordinances, because again, those are the mandatory provisions. Your general plan is advisory. So if there is something in your local ordinance that says, I'll just use something simple, right? The setback for this dwelling is 10 feet from the property line. And someone brings in an application that proposes a home that is 10 feet from a property line, then they're entitled to approval. You can't look to some sort of a statement in the general plan that says, oh, we want our communities to be open and have open space, and say, well, we don't think that this setback is enough to fulfill that vision, and so we're going to deny it. You can't do that, right? Because again, the general plan is advisory. Most general plans, if they're done right, kind of are speaking in more general language. That's largely because they don't have any specific legal effect, right? It's just an advisory document. And then you're looking to your ordinance for the implementation of what those goals are in the general plan. So that's kind of how each of those interacts with one another. Is that answering your question, or do you have specifics?
No, that's helpful. Thank you.
Jordan, though, what if somebody wants, if your future land use map in your general plan call for a certain density in the zone, and they want to downzone that, we require a general plan amendment before that's even considered.
Okay, which is appropriate, and your local ordinance can make your certain aspects of your general plan mandatory, right? So if a legislative decision or an application for a legislative change comes in, you should be looking to your general plan, right? And if they don't align with one another, they're not consistent with one another, then you should take that into consideration. And if your local ordinance says that a zone change does need to be in compliance with the general plan, then it does, right? So you definitely want to look at those as well, for sure.
Maybe you're gonna cover this as we move along during the evening, but I would like some discussion on noticing the public when we're making a legislative decision. How can we, any recommendations for improving our notice procedures?
Yeah, so I mean, there are specific notice requirements, right, for when you do a zone change, and certain individuals are required to be given specific notice, right, if their property is gonna be specifically affected. But you're talking more about how do we get the word out to the public so they can come participate? That is an age-old question. It's a great question. Social media is the two-headed dragon, right? It's a wonderful blessing in a lot of ways, but it can also create a lot of difficulties. But that's one way to do it, right? Put that out on social media. Signs on property, you know, can help people to know when things are coming down the pipe. Inevitably, the reality is our system, and I didn't realize this until I became a planner and a lawyer and got into local government. It presumes an engaged community. And when you don't have an engaged community, it's hard to not have the scenarios where someone comes into the hearing for the administrative decision and says, wait a second, why wasn't I consulted? Why wasn't there a meeting about this? There was, but it wasn't important enough for you to care, right? Or yeah, maybe they just don't know, right? Maybe they didn't know the process, okay? And so, you know, educating people about that process. One thing that I really like, and I'm not saying you have to do this, but, and this is just, you know, best practice according to Jordan, but I really like it when there's everyone has city days or town days. It's Pleasant View has something like that. If you have,
Founders Day,
what is it called?
Founders Day.
Founders Day.
You've never heard of it?
Now I have.
Well,
I actually have Founders Day
It's the fourth Saturday in June.
for Saturday.
Saturday.
Okay, very good. Have a booth, right, at Founder's Day. At all the things, you know, if you have a rodeo, if you have, you know, bounce houses set up. I love it when I go to one of those, and there's, you know, you got community development out there, right? And they have the general plan on a table, and they're saying, hey, come give us your input, right? I think that kind of stuff is great. Really just anything and everything. Communities, there are conversations with your community, right? And your neighbors. There isn't any one right way to do it. But I think being open and transparent, especially with legislative decisions, is never a bad thing.
Thank you.
Can I just make one additional thought?
Yes, please.
On this issue of administrative versus legislative, the only time that an administrative decision should start to have any sort of, not exactly legislative, but interpretive element to it is, would be under a conditional use permit, where you're working to determine what, like you referenced earlier, what are referred to in state law as reasonably anticipated detrimental effects. That you have the ability as a commission, as a land use authority to determine what conditions could cause problems for the neighbors, is the non-technical way of saying it, and to work to mitigate them. You're not permitted to do something, to impose an additional condition that entirely eliminates them, but to lessen them, roughly speaking. And so in that action, it's not formally legislative, but on that type of application for a conditional use permit, but you can spell out, if the applicant, you can add these additional development standards that are custom to the project and site at the moment that a decision is being made, to say these additional conditions will mitigate these reasonably anticipated detrimental effects for the neighbors, and spell those out. But again, you'll want to put those on the record, and that kind of has a little bit of a legislative feel, but that's the only time which, really speaking, there should be customization in the moment of decision.
Yeah, and that's the part where we're talking about regarding factual determinations, right? So in addition, and that was well said, Brandon, right? You have, for your conditional use permits, you're gonna have standards in your ordinance, right? And maybe if you go down, I think one of the later slides has examples of conditional uses, or standards for conditional use permits.
Okay.
Going, it's near the end.
Okay.
Right there.
Okay.
One more. Yeah, so examples of standards that may address potential detrimental effects. So I think I pulled these were standards that I pulled from Harriman City's ordinance. Right, so you're gonna have something like this somewhere in your ordinance that says, these are standards for imposing conditions on conditional use permits. So impacts to street service levels, impacts to the adequacy of utilities, impacts on connectivity, related to noise, odors, and dust and fumes, impacts related to hours of operation, right? So yeah, if you have a conditional use permit that comes in and you say, hey, this is kind of the quintessential conditional use permit application is for a church in a residential area. Because a church has kind of, you know, some commercial aspects to it, right? Parking lots, lighting, large groups that come to it, right? And so that's one that I typically see. Churches are conditionally permitted uses, right, in residential zones, because they may have some of these impacts on typical residential living, right? And so you can look at the application, you can look at your standards and the ordinances, and then you can say, okay, is this use going to have any detrimental, reasonably anticipated detrimental effects related to these standards, right? They have to relate them to your standards, okay? And if you can identify some, then yeah, you can say, okay, this proposal, you know, on you know, once a week, 300 people per hour come here, right, in cars. And so there's going to be an impact on street levels, or there's going to be an impact on traffic or something like that, right? Or lighting, and so we're going to impose a condition that you have X number of parking spaces to accommodate that traffic, right? So I've provided evidence, right? I said, okay, this use is, the application is showing this is how many people are going to come to it, right? And so that's a fact. And so we're going to impose a condition that required, and according to the standards in our ordinances, because we can address traffic and parking, right? And so because of that, we're going to impose a condition that says they need to have X number of parking spaces. So you looked at it, you provided substantial, and you put that in the record, right? You provided substantial evidence, you made a factual determination, and then you can impose that additional condition that isn't explicitly stated in your ordinance, right?
Going to go back to the
Yeah.
earlier slides. Okay.
Okay. Good question. Anything else? Should we touch on exactions, or do you have something else that's kind of burning in mind right now? Okay. So exactions, and this is kind of another one that in some ways is similar to, in a lot of ways, conditional use permits, and that when a subdivision application comes in, right, then you can require okay, so an exaction, here we go. It's a mandatory contribution required by a government entity as a condition of approval for a development application, okay? So when development applications come in, you can require the developer to offset their own impacts on your ability to provide them services. So what are the services that you provide development typically, right? Roads and utilities are the typical ones, okay? If you think about it, right, who owns those roads and utilities after the developer puts them in place? They dedicate them over to the city. So you're requiring them to contribute money and property to the city. It could be a taking of property, right? Because you're saying, hey, you have to give us your property. The courts have said that you can do that and it's lawful and it's not a taking insofar as you're only requiring them to offset their own impacts, okay? And so you want, you know, requirements in your ordinances, but typically you can also impose conditions based upon specific applications, right? You got to provide substantial evidence, so, okay? But as long as you're requiring them to only offset their own impacts, to provide roads that serve their development, to provide the utilities that serve their development, then you're within the bounds of the law, right? But if you start requiring them to build infrastructure or improvements that offset more than their own impact, now that's when you're getting into takings concerns, constitutional concerns, right? And the Constitution trumps your ordinances. So if your ordinance says, hey, you know, for every subdivision, they need to provide X, Y, and Z, And those X, Y, and Z are offsetting impacts that aren't related to the development, but they're related more to the community as a whole or to someone else's development. Then you're getting into the realm of potentially providing or requiring an unlawful exaction. Does that make sense? Go ahead.
We have studies to prove our impact fees.
Perfect.
So this makes me think of the canal that we have.
Okay.
So if somebody, so I own frontage on the canal. But the canal's open. If somebody were to build, I think they're required to enclose that section.
Okay.
Is that true? I don't know.
That's only if the canal company forces you to.
So that would be the canal company doing that, not the city. I was just wondering if that's what this is kind of talking about, like.
It could be, right? I mean, if you
It's
as,
in our ordinance, but I don't think it is.
yeah, I mean, if there were one typical scenario I see there is sometimes some, and this probably isn't your situation, but this is what I'm thinking of as you say that, right? Is there's maybe a canal that runs through a property and then the property owner comes in and develops and there's something in the ordinance that says, hey, we want to have beautiful regional trails. And so you need to, and we want to put a trail over that canal, right? And we have an agreement with the canal company to do that. And as development comes through, we're taking the opportunity to improve certain areas, right? If that's a regional trail, right, then, and it's gonna be a public trail and it's gonna benefit the public as a whole, it's what we refer to as a system improvement, as opposed to just an improvement that's a project improvement that serves that individual development. Then requiring that owner to construct that improvement may be requiring them to offset more than their own impacts. And- Okay, and there's different ways to address that, right? So I mean, you can still say, hey, we want you to construct this as part of your development, but we're gonna contribute, right? We're gonna cost share with you. That's one way to address it, right? And so that way you get the improvement you need, but you're not requiring them to offset the impacts that are beyond their own, right? So it's okay to have these requirements in your ordinances that address system level improvements and system level concerns. Just recognize that when a developer comes in and the ordinance requires them to build that system improvement, you may need to help, right? You may need to contribute funds from some other source, whether that's impact fees or, you know, a bond or whatever, right? But you need to go through that. You need to constantly have that in your mind of, okay, are we only requiring this developer to provide services that offset the impacts of the development? Or are we requiring it to provide services that offset impacts that are more system-wide, system level? So maybe again, you have another typical scenario, right? A developer brings in development proposal. Go down one slide, if you would.
Yeah, sure.
Maybe one more. I thought I had a picture somewhere going right there, right? So that kind of, that's just an example subdivision, right? All of those roads that are internal and serve this, that provide access to those individual lots, those are project improvements. Those lots need those roads to be able to get access, okay? But this road, I'm gonna sit away from the microphone, sorry. This one, right? As you start to get outside the development, and you have a road that isn't just a local road, but maybe it's an arterial or a collector. If you say, hey, developer, because that abuts your property and because our local ordinance says we can require you to build all roads that touch your property, we're gonna require you to build that entire stretch of that road, right? All 120 feet of it or whatever, right? Is that offsetting their impact on that road alone? Or is it starting to offset the impact that, you know, of the community that needs this arterial road to provide service to your community, right? So that would be a scenario where you're probably starting to get into, we need to contribute some impact fees if we want them to build that entire road, right? Or find some other way to help contribute. Does that make sense? I feel like I'm confusing someone. No?
Can I,
Okay.
I think I have an example that might help. So with a system-wide improvement, if one of these roads is like an arterial, some municipalities, what they'll do is they'll say, well, if the additional width from the local road, they'll say we cover the middle, 20 or 10 feet of asphalt, depending on what the difference is between them. And that covers the difference between a project improvement and system improvement, with an arterial or other wider road being the system improvement that serves the community as a whole instead of just the project.
Yeah, yeah, so let's say that that road, so maybe this guy brings in a proposal and he has this road right here, but on your general plan, you have an arterial that runs right along that same alignment, right? Then what you're talking about is upsizing, right? So it's like, okay, you have this road and you're depicting it as a local because that's all you need to serve your development. But our master transportation plan has that as an arterial road. Then yeah, you could work with the developer to say, okay, you would be responsible in that case, probably for a local road, which I don't know, would probably be like a 36 or a 66 foot cross section, whatever, right? But we need it to be an arterial. And so you look at the difference in what it would cost to build a local road and that arterial road, and the city covers the cost of providing the arterial, right? That would be an appropriate way to address the circumstance in a way that requires them to offset their impacts, but not other people's impacts.
Can you clarify Utah versus other states? Other states I've had developments in,
Okay.
they've had reimbursement agreements where you upsized, you oversized, and then for a period of 10 or 15 years, you were reimbursed.
Yeah.
If other people development, does Utah have anything like that?
It allows for it. Yep, you can do that. We refer to them as reimbursement or pioneering agreements, right? You can totally do them. It's totally up to the local government whether or not you want to allow those in any given case. And that is one way of addressing what we refer to as the pioneering problem, right? Where someone needs to bring in infrastructure to a new area, right? So, you know, your community is right here and someone's proposing development out here. There needs to be a road that gets out to that development, right? And, you know, if you require this developer to build that entire road, then he's going to be offsetting impacts of properties all along that stretch, right? So the problem with that is that you can't tell that developer to build that road. You can't require them to build it as a condition of approval. At the same time, you can tell them, hey, these are the services that you need in order to serve development out here, right? And so it kind of puts them in this catch-22 of, do they build the road and recognizing that, you know, voluntarily, do they go ahead and say, I'm willing to build this road because I really want this development right now, right? You can't require them to, but they can voluntarily choose to, and you can tell them that they can't build that development until there is a road out to them, right? One way that communities will address that, because they want to promote or encourage growth, is to say, okay, developer, if you build that, if you choose to, then we'll also enter into a pioneering agreement or a reimbursement agreement. And over time, as we collect impact fees, as other development occurs along that area, we'll reimburse you a portion of those impact fees for the costs that you incurred to build that road, right? So yeah, that's totally appropriate, for sure. But you're not required to do it, but that is a tool you have available, for sure, so, yeah. Good questions.
Jordan, I'm just wondering if you could, on this theme of exactions, if it'd be helpful to possibly just talk about the legal tests of rough proportionality and essential nexus.
Yeah, so rough proportionality and essential nexus, you have let's see, there's a slide, I think, if you go up, go back up. So right there, okay, so this is state law. When I say, and I use the words that you can only require a developer to offset their own impacts and no one else's, that is a simple way to think about this test, the rough proportionality test, right? So there has to be an essential link that exists between a legitimate government interest and each exaction. So if I am proposing a development, then the city comes to me and says, hey, you need to put in roads to provide access to your development, right? That's the essential link, okay? So there's a link between the proposed development and the requirement. This development needs access, so I'm going to require you to put in roads to provide access, okay? It kind of sounds common sense. Hopefully it sounds common sense. But there have been cases where they say, hey, there's a development here and we want you to build us a public building. Right, a new city center, if you want this subdivision approved, right? There's no essential nexus between the need for a city center and the development of a residential subdivision, right? So usually that one kind of works its way out. And then the exaction is roughly proportionate in nature and extent to the impact of the proposed development. That's just a fancy way of saying you can only require them to offset their own costs, right? Like we talked about. And if you require them to do more, then it becomes not proportionate or equivalent, as the courts have said, and you're requiring too much. Is that what you're talking about, Brandon? Or is there
Yeah.
something specific you want to talk about, or?
I guess just a little bit of commentary, which is that when Jordan and I were discussing this training, I just mentioned that one of the reasons I felt like this would be the right training for the commission at this time is that there's sort of what I'd call layers of law. So there's the Constitution, we know, is the governing document of our entire nation. Underneath that, how the Constitution is often implemented, though, is then through case law. And so you turn to case law. So this standard of rough proportionality and an essential nexus came from two different Supreme Court cases that said this is the limit of government authority on these issues of requiring exactions. And so you turn to that case law that sets a precedent for what the limits of local government power are that's related to the Constitution. And then the next layer down from that law is state law. And the state law often will make commentary on these rough proportionality tests and how it's applied here in Utah. And then there's local ordinance. And so what I'm really trying to say is that our ordinances operate within a larger framework of constitutional and state law. And oftentimes before we even bring you a project as staff, we've had a number of discussions about what the boundaries of what exactions can be required, whether they're within those tests, et cetera. And we work with the developer to inform them of that and figure out how those requirements can be met. And then once they've proposed a project that meets something that staff feels comfortable with and have provided the plans to support those exactions, then we bring it to you. But that sometimes happens quite a bit behind the scenes. And I just want you to be aware of that because that framework is helpful, in my opinion, for you to understand that there's this, I guess I'd call it a sweet spot of ordinance and law that's the enforceable, administratable boundaries of ordinances and laws, and that they operate within this, I call them nesting dolls, starting with the Constitution and then downward of, what and how much you can enforce ordinances with the intent to enforce them to every degree that you can within what's legal based on that framework.
Yeah, and it's important to remember that, right? 97, 98, 99% of the time, it shouldn't muddy the waters, right? Most of the time, you're just looking at your ordinances, you're applying them, you're making sure that the application of the rule applies. But the whole reason for this conversation about exaction, what I typically tell people is if you get the scenario and now having this framework in your mind, right? You look at a proposed application and you look at the requirements that you're imposing and you say, man, we're requiring them to do more than their fair share. That's when you should have the conversation about whether or not the constitutional exaction principles apply, and you need to either figure out some sort of a cost sharing agreement or require less than what you otherwise would. Does that make sense? Hopefully.
And these legal standards, by the way, are actually in our ordinance and our subdivision ordinance. They say that, the ordinance is enforceable to the degree that meets these legal tests. So.
Perfect. Yeah, that kind of stuff is good to have. Yeah, sometimes you'll see ordinances where there's an appeal process, right? So a property owner can say, hey, I think you're requiring more than my fair share. And then it kind of kicks them into this appeal process with the hearing officer or something like that, right? To be able to kind of find the right balance. Because you are also operating in a world where you need to follow what's meant for ordinances. And don't forget that, right? Okay. All right. Anything else? You want to go back up to the Jeopardy board? Once we hit the hour mark, people start getting tired of listening to the attorney. So I totally what's that?
We're getting quiz now?
No,
There should be.
I'm just saying.
There should be.
I won't hold it against you when you say.
Jordan.
if you say we're done, but yeah, are there any other questions you want to talk through? I think the longest I've ever gone is 2.5 hours, if you want to break the record. Sorry.
Jeff had a drink, Jeff was expecting.
Poor poker face, Jeff. I don't blame him, though.
I would actually like to hear a little bit about short-term rentals.
I'm just gonna. Twist it out because
We're out of time, but.
We're done for now. We've actually been talking about this, and it's been a discussion for the last couple of months,
Okay,
trying to be ahead of the game with what might be coming from the legislative body above us, right? So what do you see coming, or what do you think kind of restrictions are gonna be?
yeah, you know, I've been pretty surprised, I don't want to say surprised, but maybe, yeah. They've largely left it up to you guys with short-term rentals, right? They've stepped in on accessory dwelling units.
And that's the one too that I think they're referring to.
Yeah, well, it's both.
Detached, yeah.
Yes.
Okay,
Yeah.
detached, oh yeah, so accessory dwelling units, I think that one is on the table, right? I mean, we've seen them allow internal accessory dwelling units. Everyone seems to agree that accessory dwelling units are kind of a low-hanging fruit in the affordable housing conversation, okay? And so I wouldn't be surprised in the next few years if it goes either way, right? That they say, yeah, you need to allow them, or no, you don't. I mean, we did see the bill, from Representative Ward this year, that basically said, hey, if someone brings in an application that proposes moderate income housing on like 5,000 square foot lots, then they're entitled as of right, no matter what your zoning says. I watched that one really closely because I was curious to see what kind of the climate is, right? But he didn't get support for it, right? So the legislature still does look at local governments and says, yeah, they are best positions in a lot of ways to decide what is best for their communities. At the same time, there's this heavy pressure, right? That housing prices are going up and we need to find units for people to live in that are affordable. And so, yeah, ADUs, I think that is, I think everyone views that as one of those areas where that's a way to get some housing on the table quickly and that is more on the affordable side. Short-term rentals, though, I think that's viewed largely as kind of an economic thing, you know? And so really what I tell people with short-term rentals, I mean, you know, the state has come down and said you can't use postings as your only method of enforcing, right? On short-term rentals. But outside of that, it's really up to you guys whether or not and where you allow short-term rentals. But be specific, right? There's a Utah Supreme Court case that says, you know, there's this fight before short-term rentals were cool, right? Before Airbnbs and things like that. There was something at the mouth of one of the Cottonwoods where it was kind of a ski lodge that was being used in a residential area. Someone was using it as a short-term rental. And the local government said, you know what, you can't do that. And the court said, yeah, they can, right? Because all that their law said was, you can do residences, okay? Whether it's long-term rental, short-term rental, ownership, whatever, right? It just said residences, and they were using it as a residence. They were renting it out to families. And so whether that family stayed there for one night or 20 nights or 180 nights or whatever, that's all that the ordinance says is that it's residences. So if you want to differentiate between what a long-term rental is and a short-term rental is, and then say where each of those is allowed, just be specific in your ordinances, right? So. Any other specific questions about short-term rentals or?
Not so much the short term as the ADUs. If
Yeah.
you could kind of go through that a little bit more closely. What other cities are doing?
That's a good question. I mean, it's pretty straightforward, right? I mean, if there's a house and someone can, according to the standards that are, according to kind of all the requirements that are in state law, right? So you can require parking, you can require certain things, you know, there's just lists, I can't think of all of them right now.
Single family.
Yeah, it's a single family dwelling, it has to be within the footprint of the home, right? It can't be detached. Then if they can check all of those boxes, then they get to have another unit in their home as long as the home is owner occupied. Right, because if it's not owner occupied and you're renting out both units, that's considered a duplex. And you can still prohibit duplexes, right, rentals and both. But as long as the person is complying with all those rules, and hopefully you have something now in your local ordinance that reflects that. Yeah,
Yeah, one of our moderate income housing goals is to look at the detached ADUs because
Oh.
we were under the impression that, and I've heard from some legislators that they're looking at possibly requiring
Okay.
that option.
Okay.
But it would look very much like a tax.
So even there, yeah, you could do those same type of things, but you could also say it has to be at least this much square footage, right?
Well, footprint. And so
Footprint, so you don't have this little tiny home.
you
sitting
can
in
look
the
at
back wall.
setbacks, you can look at setbacks, footprint, all of that, so that you get the product you.
yeah, and so as far as detached goes, I mean, if you're in land use, copying others is fully valid, right, and actually recommended in most cases. I would say probably Salt Lake City is kind of on the leading edge of having experience with detached accessory dwelling units. And so I'm not saying go and just pull their ordinances, because you guys are different than Salt Lake City, right, and you want your own look and feel. But you can kind of go there and look for a framework or kind of a template to go off of. You know, when I was working as a planner, I would go look in, you know, the communities around me, and if someone brought in a proposal and said, hey, you know, we want to do, like, the one I can think of is people wanting to start doing townhomes in commercial areas, right? Interesting idea, right? So I looked at communities around me that allowed for that kind of stuff. And then I even called up their planner, right? And said, hey, I found this ordinance that looks like something we might want to do. What are the pros and cons you've seen with it? What are the good parts of it? What are the pitfalls, right? And so finding communities that do allow detached accessory dwelling units, calling them up, asking them how it's going, you know, what they're experiencing with it, that's a good way to approach that. So. And then, yeah, also, is again, how to allow them and what contexts to allow them, that's a legislative decision. So, you know, get the public input so you don't have sticker shock as well, right? So.
If I have a question, but I
Yeah.
want to make sure that the commission has the opportunity to go first if they have any other questions, or mine doesn't have to take precedent. Okay.
This is where I bring up song and dance.
I wanted to see if you could talk about vested rights. We've covered it a little bit.
Yeah.
But so we need to go back to a couple slides to set this foundation. Mainly, I'm trying to get to the issue of exceptions to vested rights. It's not a very common thing, but it's one of those things that's also important. I've seen it come up a few times. So if, you know, I want to get to exceptions on
Yeah.
vested rights. If you're,
Yeah, you don't need to go back.
Okay.
I can just summarize. So when we talk about a vested right, essentially what we're talking about is the whole thing that Brandon explained with this monopoly analogy, right? Is that you determine what the rules are beforehand, you agree upon what the rules are, and then when someone brings in an application, when they start quote unquote playing the game, they submit an application, they pay a fee, and the review process begins. Then the rules lock in place. So what the Utah Supreme Court said is at that point, you can't change the rules midstream, right? You can't change the rules anymore. And so they get a vested right, and they get to have their application reviewed according to the ordinances that are in place at the time they apply. There's two exceptions. One is if you have already formally initiated procedures to amend your ordinance, right? And so maybe you did that, you know, March 1, and then someone brings in an application on March 3rd. Then for 180 days from March 1, they're on notice that proceed at your own risk, kind of a thing, right? There's an ordinance that was initiated, and it may affect the approval of your application, right? So if there's a pending ordinance at the time that someone gets a vested right, then they may be subject to any changes that finally come of that pending ordinance. If you get something in place within 180 days after you start the pending ordinance, right? Something that's really important here is your pending ordinance needs to be specific about what it's changing, right? So you can't just put a pending ordinance in place that says, we're looking at zoning, right? It has to be specific enough that someone can look at it and say, oh yeah, that very well could affect my application, right? And if it does all that, then yeah, you have that kind of a grace period from when they submitted their application until the end of your 180 days to get something in place that's gonna be applicable, and that's an exception to the vested rights rule. The other one is that on the record, you make a compelling countervailing public interest, or the compelling countervailing public interest should be jeopardized if you approve the application. So the example that's always used here is, you know, someone brings in a building permit application to build on a lot, and then 2 days later, the home next door begins to slide down the mountain, right? You can say, you know what, we're going to put a pause here, and we're gonna look at some things. And if you determine that a compelling countervailing public interest may be jeopardized, if you apply the rules that are applicable to that application, in other words, you need to change some rules, right? Then if you make a finding on the record that a compelling countervailing public interest will be jeopardized, then you can change the rules applicable to that application as well, right? Very narrow. You want to have lots of evidence. You're probably going to get your attorney involved, right? But if you can do that, then that's another scenario where, you know, the public interest outweighs the vested rights of individuals.
So can you give us, there's this example of that you've used of a hill, like it's sliding down, is like a home sliding down a hill because of slope instability,
Yeah.
soil instability. Are there other examples? I would guess that this typically applies to, you know, geological hazards. Would it also, what else would it apply to? And as one possibility, you know, if there's like an additional setback, if there's a road that's been identified on the general plan and someone's trying to build a home, you know, you need an extra 10 feet setback or something.
I would say that would not be the scenario,
Okay.
right? It's like very serious public health and safety type issues. Right?
Okay.
Yeah, if it's just a scenario where you're looking at it and saying, ooh, we missed something here, you know, it'd be better do this kind of a thing. Those aren't the scenarios, you know, so yeah, public health and safety, oh my goodness, we're actually out of water, right? Or, you know, the sewer lift station is overflowing and backflowing in people's homes, right? Like serious public health and safety stuff, compelling countervailing public interest is going to be jeopardized, kind of thing, right? Those are the scenarios that we're talking about. That's why I say it's going to be very narrow that you use those for sure. So, questions?
We can keep going better.
Okay.
I was telling Zez, I'm trying to keep someone on time. Because I know a lot of.
Great questions, guys. Thanks for having me.
Hey, Jordan, thank you so much. Come on. Thank you.
Oh, yeah, no, you're good.
Julie, any other questions?
I'm
before we-
sorry, I'm not helping manage. I sat back here. This is my.
So I've asked her on, she's put herself on mute.
Okay.
So
All right.
Thank you,
Okay.
Jordan.
Thank you so much for.
Actually, I do have a question.
It's a lot of shame.
Okay. I don't know if the other commissioners are also interested, but I would love to have a printed copy of the slides as a resource. Jordan, would you be okay if if Brandon made a copy of those slides and made a packet for each of us?
And Julie, for your information, we have those here tonight, so maybe Brandon can just email that to you.
Is this
Okay.
all of them?
He did email it to me. I just wanted a written copy, but I didn't know that you all had that. So that's great.
That was an easy one. Very good.
Oh, we have one for copy, Julie, if you want one.
That would be
Oh,
great.
wait. Development agreements. Real quick. We're gonna be like, we talked about this yesterday.
Yeah.
Development agreements, pros and cons versus CCNRs.
CCNRs.
Mm-hmm.
So explain a little bit what the difference is.
Help me out, Brandon.
how would you use the two differently? Sometimes, the reason I ask is often through a development agreement, you'll put in place requirements that you then record against the property and that apply in perpetuity. So what do you mean by, what's the difference, what difference are you talking about?
Well, I guess I'm not entirely sure what Sarah's getting at, but
So,
go ahead.
by the development that we're
Yeah.
discussing at Hillside Master Plan.
Okay,
And we want to be very specific, to help the developer and to make sure that the city also gets exactly what we need, what we want, the whole thing. So we're looking at, writing language and ordinances, doing overlay, creating a new zone, all of it. And
Okay.
then also to allow some movement and whatever, how do we, get open space and trails and whatever? What's the benefit of having it, a development agreement versus, what did you call them, CCNRs?
Yeah,
well, yeah, and admittedly, CCNRs, that's something you're gonna have to negotiate with the developer anyway, right? Like, you
Right.
can't just impose CCNRs upon a developer. But through a development agreement, so I mean, kind of the two different ways is you can just put in place kind of your standard zoning ordinances. Then, yeah, you can put overlay zones on that, right? But then you're just looking to those zoning ordinances and making sure that they comply. The added benefit potentially of a development agreement is it allows the parties to sit down. The development agreements are kind of referred to as very flexible zoning tools. So it allows you to enter into a negotiation with them, right? To kind of, I mean, the daybreak, that was done largely by development
Yes.
agreement, right?
But how do you do it so that we've been burning that, like,
Yeah, I mean, it's what you said
it
earlier.
needs to be written by an attorney.
You need to have a lot of resources.
Yes, and your resources.
Yep, and you need to negotiate it and you need to have it in a forum that everyone is comfortable with before you enact it and pass it, right? But it's gonna take a lot of negotiation, it's gonna take a lot of time, it's gonna take buy-in from all the parties. But it can produce some really good development if you have cooperative partners.
But your base layer, you have your ordinance and your zoning and all that language in place, and then, to put a development.
That's typically how it's done. Yeah, I mean, you don't have to actually, right?
Better.
So I mean, if someone can come in and say, hey, we have this beautiful pristine piece of land, 50 acres, and we want to make it great. And you can just start, and it's zoned agricultural right now, right?
Sure.
I mean, you can just do a development agreement, and put everything into the development agreement. And then,
Why would you want to do that, if you don't have any zoning or ordinance? to back
well,
it
so
up?
then you pass the development agreement as a legislative act, and that becomes the zoning ordinance for that development. Right.
and
So the
so,
development
No,
agreement
that's
reads
not
like,
spot zoning.
as long as it's part of some greater plan that benefits the public interest, right? So
That's right.
again, I'm talking about like a 50-acre parcel.
Oh, I know. Yeah,
Right.
yeah.
And yeah, you can come up with a plan and you go through the public process with it, right? And I mean, that's essentially like how Daybreak was done, right?
I think I would rather do a general plan than the first.
Yeah,
So-
and there's a lot of different ways you can do it, but that's one legitimate way of doing it, right?
Yeah, no.
And then the other way is to get the zoning in place
Yes,
and then to tweak it through a development.
yes,
So,
that's.
if I could just offer a
Anyway,
couple
cool.
thoughts on that topic. So
Yeah.
development agreement will function as custom zoning for a specific project. The goal of that is to ensure that the development agreement reflects the public interests,
Yes,
which I think is your concern. First, and then the second issue is that,
helps the developer too.
with the development agreement, back to the issue about CCNRs is that, well, so there's been a change in state law in the last 2 or 3 years that development agreements are legislative acts and need to go through the same process as a rezone, meaning that they need a public hearing in order to be adopted.
If they make legislative decisions. Yep.
Yes,
Exactly.
okay.
Yep.
So there's an opportunity for the public to comment on those, and again, that's to assist in making sure the public interest is met. And then the development agreements essentially are the difference fundamentally to me. A CCNR is fundamentally private zoning for a property owner or an applicant where they can impose their own standards. But with a development agreement, after it's been enacted in its legislative process, you still can administer it and do approvals for it as custom zoning with approval by the municipality, by staff et cetera, to say, okay, this meets the standards, this doesn't. And so you can craft the language very specifically so that it can be administered by staff or DRC, something like that, to check the boxes and see if it makes those rules, if you write the language tightly enough to review it.
Yeah, it takes a lot more effort, it takes a lot more administration, right? But it also has the ability to produce.
Exactly.
I've overstayed my welcome. guys.
Sorry.
Okay, thank you.
Thanks.
Okay, we're gonna move on, try to keep these guys in and out. And we're gonna move to commission business, is there anything on the commission business that needs to be addressed now? I'm gonna turn it over to staff business, and Brandon, I messed up and we didn't introduce Tammy, so I'm gonna have to do it.
Oh,
What's her new rule? How long she's been here, what, one full day, and we're dumping all this on you? And secondly,
so we're really excited to have Tammy Evison. Did I get your last name right? Evison, okay. She's joined our staff as a planning technical assistant. And she's done a great job in the 2 weeks that she's been here. We were very impressed with her in the interview process, very excited to have her on board. And she's shown that she's super eager to learn. She puts up with my little mini lectures on land use to help bring her along and increase her knowledge base. But do you have anything that you want to say, Tammy, or anything you want to share?
welcome, we appreciate you being here with us. So, anything else from the staff? Brandon?
I don't have anything.
No,
Sarah, anything earth shattering from the city council?
Earth shattering.
Come on, they just had a CERT program.
Yes.
yeah, we had start getting tonight.
Oh, well, we got our second pickleball. It's for the parking that we realized needed to come before the pickleball complex. But RAM approved it, even without me voting on it. I had to recuse myself. Anyway, the parking for that, and so that's gonna be moving forward, with that. Let's see, we're already meeting for Founder's Day, March 9th, anyway, just to start the conversations and stuff, and there is a 20-year anniversary open house next week. If you want to stop by the Education Senior Center. I don't know how many of you know that we contribute annually to that senior center. They have a lot of programs, and it's just very well ran, and if you want to come, it's next week on the, let me tell you real quick, when is it? Anyway, you should go if you want to,
Thursday, is it the 19th? Is that what
it is, sorry.
Oh, is it Tuesday the 19th?
Yeah, but it's their 20-year anniversary, and they'll have stuff all there. So take a visit, your taxpayer dollars are paying for it anyway, you might as well.
There you go. All right, if we have no other business tonight, I'm gonna make a motion to adjourn. I'll second it. Any made motion, for the record, in attendance tonight is Sean, Dean, Jeff, mine, David, Julie online, and so now we have on record. All in favor, say aye.
Aye.
Aye. Thank you, everybody, for coming tonight. For the record, I think I got to 47 phone calls, man. Oh, yeah, we made some calls because you didn't come in tonight.
Oh,
47 phone calls.
And I think,
I apologize,
I think it's Spencer.
you know.
No?
So I apologize, I didn't step out.